All right, we're already deep in procedural territory. This isn't just a hearing, it's a legal post-mortem of a financial dispute. Notice how the judge immediately anchors the case in prior rulings. This is a classic. We've already decided most of this. Now prove the numbers situation.
So, as you know, tell me how to pronounce your last name so I say it right.
Tokajer.
Oh, just like it's spelled. Okay.
Just like it's spelled. Yes, ma'am.
Okay. So, Mr. Tokajer, obviously, you know, I've already entered sort of a partial order indicating that Mr. Tharps is entitled to a full judgment on the dispossessory action, which I've already entered, and then essentially is entitled to a default judgment as to his counterclaims, but because of the nature of the remedies that were sought, one, evidence of the damages, and then two, any equitable or other remedies, the court, thought that in order, and I think you pointed out, that in order for us to actually finalize that judgment in Mr. Tharps' favor, we'd need to have a hearing, and so that's what we're here for today.
Yes, Your Honor. Thank you for getting this hearing so quickly on the schedule. I appreciate you moving things along. It's a pleasure. I imagine you don't really need me going through much of the facts unless you want me to do a quick recap.
No, sir. I have, in ruling on the underlying motion, I think it was a partial motion for summary judgment, I did familiarize myself with the facts. And so I am aware that this ultimately is a dispute where Mr. Tharps owns a piece of property, that he needed some financial assistance, obtained it from, I think they're technically the plaintiffs because of the way it's structured, needed some financial assistance, obtained it, essentially understood he was obtaining a loan, and then they attempted to assert ownership through the dispossessory and some other actions, even though your evidence I expect to hear today, what you have asserted so far, is that Mr. Tharps has fully paid back the loan with even any interest consideration that might have been attached. Yes, and so that's what I generally know about the case, and was just looking for you to present the evidence so we can finalize that judgment. Do want to just make clear, although I've already ruled on the underlying claim against the plaintiffs for the dispossessory, I do want the record to reflect, such as it is, that the plaintiffs did receive notice of all of these proceedings. They were provided with a copy of the court's ruling.
Pause here. This is important. The judge is carefully building a record that the absent plaintiffs were properly notified. In legal terms, this is procedural due process insurance. Translation. If they appeal later, this line becomes a shield for the court.
They were provided with a copy of the notice of hearing today. They are not present. Frankly, because of the procedural posture of the case and the fact that they did not respond to the summary judgment motion, I'm not surprised that they're not here. But I do just want to reflect that the court did undertake its due diligence to provide them with notice of these proceedings should they have chosen to attend.
And Your Honor, I believe they were aware of today's hearing because they did reach out to discuss settlement at some point, and we told them we would see them on Friday. So I believe they were aware of it, at least through us. If they did not receive it in the mail or didn't see it in the mail, they were told there was a hearing this Friday through my office.
Understood. With that, Mr. Tokajer, I think your original question was, do you need me to go through the facts? And no, I don't.
Now we're getting to the heart of the dispute. Was this a loan or a disguised ownership claim? The legal tension here is huge. Courts often scrutinize deed-like arrangements to determine if they're actually secured loans. This is where equity law starts flexing its muscles.
I think that what makes sense is for you to present what evidence you believe is necessary for the judgment that Mr. Tharps is seeking in his own favor.
Great. So just to say real quick, what we're seeking is, I believe at this point, the court has already construed this absolute deed to be a security instrument. So what we are seeking is cancellation of that what is now a security instrument. And we will put evidence on that Mr. Tharps has repaid the $19,000 loan. There was no interest on that, so we have put on 7% interest as required. So even with the 7% interest put onto the loan, he's actually repaid the full amount and actually overpaid by $755. Okay. And I will have Mr. Tharps testify that in just a second. There is one little bit of wrinkle here. It is in the summary judgment order and all our pleadings, is that the Yanusas, so the agreement was Mr. Tharps would pay the Yanusas. The Yanusas would apply that amount to the underlying regular monthly mortgage payment and then apply anything above that to the $19,000 Yanusa loan. Well, that was happening in general, but in 2024, the Yanusas actually started making large payments, more than the monthly mortgage payments. So there's about $50,000. The underlying mortgage was paid off in 2024.
Here's the plot twist moment. Voluntary payments. In legal doctrine, that phrase can be a game changer. If payments were truly voluntary, you usually can't claw them back later. The courtroom just shifted from who owes what to who chose to pay what and why.
And there were about $50,000 of payments made by the Yanusas. They had no obligation to make those payments. There was no consent by Mr. Tharps or authority given by Mr. Tharps to make those. So we'll be arguing, and Mr. Tharps will be testifying that those are voluntary payments and they're not entitled to any reimbursement for those. But that's a bit of the wrinkle here, and we'll also put evidence about that, as well as by evidence about attorney's fees.
Understood. Go ahead, sir.
Do you mind, Your Honor, if I share my screen?
Not at all.
Perfect. Okay.
And I did receive these materials, which I believe include this ledger and I think some bank statements from Bank of America, and did have a chance to review those very briefly. So
great. Well, do we need to swear Mr. Tharps in, or?
Yes, Mr. Tharps, will you please raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Okay.
There we go.
Had a little bit of a technical glitch there, but we got you.
And I brought him into the office so we'd have less technical glitches. So hopefully we have none.
Okay.
Mr. Tharps, do you see on your screen what's marked as Defendant's Exhibit A?
Yes.
Can you tell me what that exhibit is?
That's the breakdown, itemized payments I made to the Yanusas for the mortgage on the loan of $19,000.
Great. And the third column there, it says payment amount. Does that reflect the payments you made to the Yanusas?
The third column.
Where it says payment amount?
Yes.
Okay. And then 2 columns over, it says monthly payment on underlying mortgage. Does that represent the amount of your payment that was applied to the underlying mortgage on the property?
Yes.
And then you also see principal balance of Yanusa loan. Is that a reflection of the running balance of the loan to Yanusas over the period of time?
I'm having a little hard time hearing your volume.
Yeah, you are a little quiet, Mr. Tokager. I can hear Mr. Tharps loud and clear, but you are a little quiet, so.
Okay, give me 1 sec. Let me see if I can adjust my volume here. Or I'll just speak up. How's that? Is that better?
Well, I think your voice in here is coming on the phone or to speak on the computer, but I can hear you through the wall as well.
Let me run to his office and turn up the volume on his computer,
Okay.
if you don't mind.
Mr. Tharps, can you hear me okay?
Yes, ma'am.
Okay.
Then it's a me problem. Okay, Your Honor, give me 1 second if you don't mind.
Sure.
Can you hear us better now, though?
I can hear you just fine. Mr. Tharps, why don't you try something, sir?
Can you hear me? Ted?
Yes, sir, I can.
There we go.
Okay.
So, Mr. Tharps, I was asking you about the column that says principal balance of Yanusa loan. Is that an accurate representation of the running principal balance on the $19,000 loan with Yanusa?
Yes, it is.
And is this included with this document are bank statements and mortgage statements from your mortgage account, correct?
Correct.
And are those accurate depictions of the payments made to Yanusas and the amounts applied to the underlying mortgage?
Yes.
Your Honor, we'd like to move to enter this into evidence.
Okay, it is accepted into evidence.
Perfect. And Mr. Tharps, if we go down to the 4th page of this exhibit, can you tell me what was the total amount you paid to the Yanusas?
Total amount paid to the Yanusas, $82,333.20.
And how much of that was applied to the underlying mortgage per the agreement?
$56,993.34.
So how much did the Yanusas pocket to go towards their loan? What was the amount applied to the Yanusa loan in total?
$27,739.86.
So based upon your records and this summary, have you paid off this loan in full?
Yes.
And have you actually overpaid on this loan?
Yes.
And how much did you overpay?
$755.
And this document does include a accrual of 7% interest to the Yanusas on their loan, correct?
Correct.
I would like to show you now, Mr. Tharps, what we have marked as Defendant's Exhibit C. Do you recognize this document, Mr. Tharps?
Yes.
Okay. Can you tell me what it is?
That's a printout from the mortgage company that I was researching and found that the Yanusas was paying directly on the principal.
Great. And if we go down to page, what's marked as Tharps 003 on Defendant's Exhibit C, do you see line 323 there?
Yes.
Okay. And is that a principal payment that was applied just to principal, no interest being applied there?
Yes.
So is this a payment the Yanusas made that was above and beyond what they're required to pay for the monthly mortgage payment?
Yes.
And is that also from line 323 to 334? Are all those payments?
Yes.
And what's the amount of those payments?
$970.21.
And going down to the next page, that continues from item 335 to 346, correct?
Correct.
So on August 3rd of 2023, how many additional payments of 970.21 did the Yanusas make?
24.
And you didn't give any consent to make those?
No.
And they don't have any legal obligation to make those that you're aware of?
No.
Scrolling down to what's marked as Tharps 005, do you see line 352?
Yes.
And tell me what that is.
Another bulk payment on the principal till $10,000.
And who made that payment?
The Yanusas.
Did you give them any authority to make that payment?
No.
Did you ask them to make that payment?
No.
Did they have any legal obligation that you're aware of to make that payment?
No.
And then going down to the last page here, can you tell me what that is, Mr. Tharps?
That's a letter from the mortgage company that states that the mortgage had been paid off.
And how much was the payoff, the final payment?
$17,238.95.
And who made that payment?
The Yanusas.
Did you ask them to make that payment?
No.
Did you consent in any way to them making that payment?
No.
Did they have any legal obligation to make that payment?
No.
And I actually didn't enter this into evidence, Your Honor, but we also don't have a court reporter, so I'm not sure if you wanted me to.
Well, you know, might as well just make it official and bless it. So that was Exhibit C.
Yes, ma'am.
Mr. Tharps has officially identified it as being what he purports it to be, and so I will accept it into evidence.
Thank you, Your Honor. Now, Mr. Tharps, you did in 2024, the Yanusas, did they refute that they had loaned you money? Did they make any sort of statement that they were the owners of the property, or they considered themselves to be owners of the property at that time?
Repeat the question, please.
So this was a loan between you and the Yanusas, right?
Correct.
Did they, as of the time they filed their eviction, were they refuting that they had to transfer the property back into your name once it was fully repaid?
Did they refute it?
Yeah.
No. Yeah, to a degree. They wanted to put it on the market. They didn't want to just reverse the process with the deed.
Gotcha. So when they were filing dispossessory, they were trying to put it on the market, despite the fact that you were trying to reach out to them to work out this loan.
Correct.
That's all I have for Mr. Tharps, Your Honor.
Okay. Thank you, Mr. Tokager. Mr. Tharps, you are excused as a witness, sir.
Oh, okay.
Head back in the other room.
All right, thank you.
Musical chairs around here.
Indeed.
Okay, Your Honor. Last piece of evidence is our Defendant's Exhibit B. This is a summary of the attorney's fees with invoices attached to them. My hourly rate is $375 an hour. I have one associate who works for me. Her name is Jennifer White, and she charges $300 an hour. And I have a office manager who charges $150 an hour if there's managerial or copying tasks or that sort of thing. Those rates are reasonable given the area I practice in and my level of expertise. I do these sorts of cases regularly, handling issues with deeds and security instruments and all sorts of foreclosure issues and eviction issues. And our total attorney's fees that we've incurred as of yesterday was $33,106.20.
Okay.
So we had moved to enter Defendant's Exhibit B into evidence.
Defendant's Exhibit B is admitted.
And that is all the evidence we have to present to Your Honor.
Okay. So thank you for that, Mr. Tokager. So as I mentioned, because of the procedural posture of the case, Mr. Tharps had moved for summary judgment on his claims. And it does appear to me, as I'd already indicated, that Mr. Tharps was entitled to judgment on those claims, which included claims for equitable relief and claims for attorney's fees. And so what I would be asking for you, from you both orally right now and then in follow-up to the hearing, is what is it that you suggest the court enter in terms of, I understand the specific remedy you were requesting besides an award of damages associated with the attorney's fees, but also an order canceling any security deed or interest document that was filed against Mr. Tharps' property. Talk me through what that relief looks like, and then ultimately what I'll end up having you do is submit a document that would essentially be a final judgment that I could then edit and finalize to make sure it's providing the relief that you are seeking, Mr. Tokajer.
Thank you, Your Honor. So what we would be seeking is an order from the court which specifically says that the deed is a security instrument, that security instrument has been paid off by Mr. Tharps, and that is canceled as of the record, and that the Yanusas have no interest in Mr. Tharps' property. We would also request a money judgment for the $755 overpayment that Mr. Tharps made, and attorney's fees in the amount of $33,166.20, as well as an order which says that as well as an inclusion in the order that says the overage payments made by the Tharps, that they are barred from being reimbursed for those fees based upon the voluntary payment doctrine.
Did that last piece, I want to make sure that we're both comfortable that it's actually asserted in this lawsuit, because of course, you know, I ought not reach out and grab issues that are not presented to me. Now, it can certainly be maybe inferred from some effort to assert an equitable lien or an equitable right to subrogation in the fact that they filed a dispossessory and in the posture that they have taken in the case, but I'm not sure they actually requested it. What say you, sir?
We did put it in our motion for summary judgment, which was unanswered, that these were consensual payments that were made without any obligation or any sort of requirement. And that's the exact reason for the voluntary payment doctrine. So in the order you presented that we had proposed, it does say that these payments were voluntary, that there was no sort of obligation. And for judicial economy, so we don't end up right back here for another 2 years arguing about this amount, I think that the Yanusas had plenty of opportunity to contest that. They did not contest it. It was entered in an order, and for judicial economy, as well as just to, I mean, this was an entire breach of contract matter. It was them going outside of their contractual obligations, and Mr. Tharp shouldn't be punished by the fact that they went outside of their contractual obligations in breach of the contract.
Okay. Mr. Tokajer, could you take down your screen share, please?
Oh, yes.
I am advised that there is an attorney, I don't know if it's Devine or Divine, he's appeared in our Zoom. Could you tell me how to pronounce your name, sir, so I say it correctly? You're muted right now.
I'm sorry, ma'am. Good morning. Good morning.
Good morning.
I'm John Devine. This is Miss Yanusa. I do apologize. I got misconstrued. There was a Zoom. I'm down here at the courthouse.
Okay. Yeah, my staff attorney texted me just a moment ago and let me know that you had appeared at the courthouse.
Yes, ma'am.
So because that matter actually started at 9 o'clock this morning, and so we actually were wrapping up the hearing. You are here now, and so I'm trying to figure out what exactly to do in terms of your efforts to respond, Mr.
And here comes the classic late entrance complication. An attorney or someone claiming authority appears midstream, but the judge shuts it down fast. Representation rules in superior court are strict. No license, no voice. Harsh but procedurally airtight.
Tharps had presented his own testimony and the testimony of his attorney regarding attorney's fees for the final judgment that the court wanted to enter. As you probably are aware, the court had already entered a judgment indicating that Mr. Tharps was entitled to summary judgment on various claims, but the court didn't, or an order that he was entitled to a judgment on those various claims. The purpose of today's hearing was to get evidence regarding the remedy or damage that was sought by Mr. Tharps so that the court could enter final judgment. What say you, Mr. Devine?
Okay, well, I have Ms.
Your Honor, I don't believe Mr.
Your Honor, I just want to say that.
Hang on one second. I'm sorry, Mr. Devine. Mr. Tokager, did you have an objection?
Yeah, I'm sorry to interrupt, but I don't believe Mr. Devine is a licensed attorney. I think he's a real estate broker at most, just to make the court aware of that.
Okay. I'll
Yes,
work with that. Thank you for letting me know, Mr. Tokager. Mr. Devine, you were saying, sir?
Yes, I am in the property management that entered the dispossessory, and I got notices that Mr. Tokar had got it bound over to the Superior Court, and we was attempted to negotiate as court order to negotiate, and I did get authorization to be an authorized representative by the Yanusas to negotiate. And we had several attempts to try to get in contact with Mr. Tokar and his staff. I was working with Ms. Sanchez White, and they wanted some information about me being, of course, representative. I sent information. I sent it by certified mail. I sent it by email. And also I got an attempt to get Ms. Yanusas on the line with Mr. Tokar and gave him the negotiated offer. And we found out just a couple of days ago, after a week trying to get in contact with the office to get the answer, and we just got the answer the other day, that we have a court date today, and they rejected the offer. As it stands right now, Your Honor, what has happened? Mr. Thorpe has had entered an agreement and borrowed money from my client because of some equity.
Hey, Mr. Devine, forgive me for interrupting you, but let me tell you a couple of things. So number one, I'm aware of all that because I've already received a summary judgment motion that had a lengthy history and documentation of the money that Mr. Tharps borrowed from the Yanusas and the nature of the agreement that the parties had. And I've already ruled on all of that because the Yanusas did not file a response. Also, my understanding is that the Yanusas, as you pointed out just a moment ago, they're the ones that started this lawsuit by filing a dispossessory. And then when it was bound over, while the Yanusas may not have communicated that information to you, I'm confident that the Yanusas received the legally required notices of all of these proceedings. Also, Mr. Devine, I don't mean to be dismissive of your efforts to speak on the Yanusas' behalf, but if you're not a lawyer, you're actually not legally authorized to speak on Ms. Yanusas' behalf.
Well, if that's the case, I would respectfully just ask that because of the attorney that want to represent his father had a stroke, and I'm just here just to try to get a continuance. So he can speak on their behalf because I really feel that they really need to be heard in this case. And if you'd be so kind to give us a continuance, because the attorney would be Jay Srinath, and that his father just had to have a stroke. He just could not attend or be involved at this time. And I just doing the best I can to negotiate during the time, which I thought that I didn't need to be an attorney to negotiate with Mr. Toker.
In magistrate court, you can do that. I'm sure you probably, given your involvement in the real estate world, I'm sure you probably spend a good deal of time in magistrate court. But in the superior court, the law is clear that you have to be an attorney to be able to represent a party in a case. And so, as much as I appreciate that you are trying to represent the Yanusas' interests, I can't really accept your representations because you're not an attorney. Also, I will say that this case is really pretty far past the point of giving somebody a continuance. Hang on.
Okay.
What I will share, Mr. Devine and Ms. Yanusa, is that, look, what's going to happen at the end of today is I'm going to enter what is an actual final judgment. And when I do that, the Yanusas can take whatever legal steps they choose to take with the advice of their attorney. But there's nothing that I've heard today that would require me to continue the hearing and also completely redo the hearing I've already done this morning for the last 25 minutes before Ms. Yanusa joined us.
Well, the caveat is this, Ms. Yana, is that Yanusa has actually paid the property off.
I am aware of that. Mr. Tharps has provided me with that information and that documentation.
And what is your final judgment?
So my court's docket reflects that on, excuse me, on April the 3rd, I entered a non-final order that granted a summary judgment to Mr. Tharps on the plaintiff's dispossessory claim, and also granted a partial judgment to Mr. Tharps on the breach of contract counterclaim and attorney's fees and costs. And then the purpose of today's hearing was to talk about the final remedies so that the court could enter a final judgment on the counterclaims, or the counterclaim rather, which would be the attorney's fees and the equitable remedies that were sought by Mr. Tharps. And so that's the judgment that I'm going to enter today. Well, it actually won't be today. I've asked Mr. Tokajer to provide me with a proposed order, and then I would enter it probably early next week, depending on how quickly Mr. Tokajer can get it to me. And then, as I said, the Yanusas can take whatever, I mean, they have legal rights and remedies in response to the court entering a judgment, and they can certainly undertake those. But I'm not going to continue the matter today. As I said, my docket indicates that the Yanusas received notice of these proceedings.
And we responded to the attorneys every time that they, of course,
I understand that, sir, and I certainly always encourage the parties to be in communication with each other. But there is an obligation when you file a lawsuit and the court enters an order placing a matter on the trial calendar, or when there is a motion filed, the parties are under an obligation to respond to it, and none of those things happened. And
well, I would again, Judge, ask that I understand that you have reviewed everything, and there has been much understanding. As you can see, I'm down here at the courthouse, understanding that I was supposed to show up. Because of the situation with the attorney, his dad in the hospital stroke, he could not give them adequate representation, which he wanted to. I think that Yanusas would deserve opportunity to be heard.
So, as I said, Mr. Devine, one, you are not an attorney. Two, the Yanusas have had multiple opportunities to have responded to this lawsuit. Mr. Devine, I am speaking, and when I'm speaking, you need to stop speaking.
Yes, ma'am.
Okay. As I said, I listen. I understand the difficult situation in which the Yanusas find themselves, but at the end of the day, they have had opportunities to respond to this action and they've not responded. The court has already indicated what its ruling is going to be. It is the court's intention to go ahead and enter a final judgment, as was the intended result of today's hearing. And then, as I said, once it's entered, the Yanusas have every legal right to take up any action, and hopefully, their attorney will be fully recovered and able to provide them with assistance and guidance about what steps they might take. But for today, there is no basis for me to continue this matter. And so my intention is to go ahead and finalize the order that the court had intended to enter, which will be a final judgment. And then the Yanusas, through an attorney, can take whatever steps. Or, they can do it on their own, too, but they can't do it through a non-lawyer.
Apparently you can't, because again, are you actually saying that you're going to do a judgment knowing that the Yanusa has paid this mortgage off and render a final judgment for Mr. Tharp, knowing that he had borrowed money, have not paid, and not paid?
Mr. Devine, you again are not an attorney.
I'm just asking a question, Judge.
Excuse me, sir. I can also end your presence on my Zoom if you continue to be disrespectful to me.
I might be disrespectful,
Mr. Freehoff, please excuse Mr. Devine and Ms. Yanusa. I will enter my judgment, and if you wish to take legal action regarding
you already
appealing it, you can do so. Okay, Mr. Tokajer, where were we?
We were talking about voluntary payment doctrine and the surplus.
Yes.
So I would request that it be barred, but I understand if Your Honor doesn't feel that that was within the parameters of the litigation.
I think what would make the most sense, Mr. Tokajer, if you believe it is within the parameters, because as I said, it's certainly inferred from the procedural posture that the Yanusas took in their filings. And so why don't you include it with that context, and then I will consider that particular aspect. However, I will say, as we were discussing, I do agree with you that Mr. Tharps is entitled to a judgment of the court that declares that the deed was in fact a security interest, that the security interest has been fully paid off and is due to be canceled, that the Yanusas do not have any interest in the property pursuant to that security interest, and that Mr. Tharps is entitled to a money judgment in the amount of $755 for overpayment, and $33,106.20 for attorney's fees in pursuing this matter. And then that one open piece is whether or not the court's declaratory judgment will also include a declaration that any payments made by the Yanusas were in fact voluntary, and therefore do not provide them with a basis for an equitable lien claim or other subrogation right.
Thank you, Your Honor. That's exactly what I was thinking, so I will get that drafted up for you.
Okay, excellent. I apologize for that. It's not ideal when that occurs, and I certainly hate to dismiss someone from my Zoom, but it is what it is. As I said, if you have further contact with the Yanusas, again, as I think I've stated several times to Mr. Devine in Ms. Yanusa's presence, they certainly have they have legal rights and remedies available to them to appeal or otherwise take action regarding the judgment. But I don't believe there's a reason for me to delay entering a final judgment in this matter, given the posture of the case and where we have advanced in terms of procedure so far. Anything else that you wanted to raise with the court today, Mr. Tokajer?
Nothing else, Your Honor. Thank you very much for your time.
Okay. Thank you, Mr. Tokajer. Have a good day. Have a good weekend. And I will look forward to your order early next week, and then I'll try and get it on.
This is the wrap-up moment, what lawyers call the relief package. Cancellation of the deed, money judgment, attorney's fees, and one unresolved legal doctrine issue. Notice how the judge leaves a narrow open door only for the voluntary payment argument. Everything else is already essentially decided.